Hi guys, welcome to class 12 of our Fundamentals of Legal Research course. Today we're going to be doing an overview of civil litigation. We're going to be talking about motion practice and the appellate process. So I hope you had an opportunity to read this overview of civil litigation in Statsky, page 354 to 367. It kind of tells the story of how a civil suit, start to finish. So, in the way of a story. So I think it's super helpful. And hopefully it is a little bit of a review from things that you've learned in maybe litigation or other courses. So the first stage of civil litigation, they call it pre-litigation. And so even if you're in pre-litigation, it is like a litigation department. So you have an event, whatever that is. Is it an accident? Is it a contract? Is it some sort of tort? I don't know. So there's an event. And then one of the parties goes to an attorney for a consultation to see how the attorney can help them resolve this conflict from this event. Then the attorney might be conducting some factual investigation and some legal research, coming up with a strategy to help the client resolve this event. If there is another party involved, there will be attempts for settlement before a lawsuit is filed to see maybe we can resolve this without having to resort to going to the courts, which is an expensive proposition and a risky proposition because judges and juries, maybe aren't 100% predictable. Some things can happen that are unexpected. So if pre-litigation settlement attempts fail, you have to go ahead and file a case. So the first thing that happens if you are an attorney or working for an attorney who is representing a client is that the attorney has to file an appearance. So that is a statement to the court that this attorney represents this client. And the significance of that is that they have the authority to file materials on the client's behalf, and they can't just skedaddle. They have, before leaving a lawsuit, they need permission from the court. And if they are going to withdraw their appearance, they have to let the court know, and the court might say no if the client doesn't have other representation. So it's kind of serious to file an appearance. Okay, and then you have the actual start of the lawsuit. You have your complaint filed. So you have to figure out what the basis for your complaint is. You have to state a valid cause of action. You have to allege the elements sufficient to satisfy that course of action, that cause of action. Okay, and so you can file a complaint against a defendant. Sometimes it's a third party complaint. If you've received a complaint that's been filed against you, you would be maybe filing a complaint against a third party who hasn't been brought into the initial lawsuit, or a counterclaim. Okay, so if I'm the defendant, I have to file an answer to the complaint. How do I feel? How am I answering these allegations? Am I admitting them and am I denying them? Do I have any affirmative defenses that would bar relief? I can also move to dismiss the complaint at this time if I feel like it hasn't satisfactorily alleged a valid cause of action. Okay, so then after the complaint and the answer and initial motions to dismiss are resolved, the discovery phase starts. Okay, so discovery is the fact-finding part of the lawsuit where parties are required to disclose both documents and information to the other party because of this lawsuit. So if you are asking questions, you submit what's called interrogatories. You have questions for the other party to answer related to this cause of action. You may request admissions. You might say, well, let's avoid the time waste at trial if you're going to admit that you live at this address. So then I don't have to worry about proving that you live at this address. Or, they're also going to, a request for admission might also be a request for admission of guilt, which usually parties do not say, yeah, I'm guilty, or yes, I did this terrible thing and I was negligent or whatever. But you can eliminate some needless time at trial if you admit these through this tool called request for admission. Okay, then if you're looking for documents, you can subpoena them. And that would be subpoenas to non-parties. So if you're trying to get work records or you're trying to get medical records, you might file a subpoena. You also issue a subpoena to require parties to appear for deposition. Deposition is the place where you have a court reporter and two attorneys, and you ask a witness who is sworn to questions, and then that can maybe be used in evidence at trial, or it depends on the quality of the deposition. Okay, request for a production of documents. That is when you're asking a party for specific documents that are in their possession. If parties are not responding appropriately or in a timely fashion to discovery requests, you can file a motion with the court to compel discovery and make sure the other party responds in as soon as possible with penalties, with potential penalties if they do not. Like if they don't produce this, then they can't, they're barred from using any such evidence at trial, things like that. So then we've gone through the discovery phase, we've taken our depositions, we have all our documentation, all our evidence, all those ducks in a row. And then there's pretrial motions. So maybe there's a change of venue, you don't like where it is, you don't think it's appropriate, a motion to dismiss, maybe not just on the pleadings, but for something more severe at this point. Motion for default judgment if another party has not answered the complaint. Motion for summary judgment if you feel that there is no genuine issue of material fact and the court can make this decision solely on law alone. Or again, motion to compel discovery. Now, a lot of courts these days require alternative dispute resolution. So the alternative dispute resolution means as an alternative to going to a trial. So courts can order parties, and sometimes it can be court ordered and sometimes it can be voluntary, but you have mediation. Mediation you see a lot in family law cases. Arbitration is sometimes based on a contract. They have agreed to arbitration before going to a lawsuit. So sometimes employee-employer disputes are resolved through arbitration. A lot of union disputes are resolved through arbitration, and contract disputes. Sometimes there's just judge-hosted settlement conferences that are required before you actually go to trial. And yeah, three options. They could be required by the court. Rules generally just ordered by the specific judge, or parties can voluntarily agree to it, or maybe it is subject to the relationship. So these union versus employer relationships, they have mandatory arbitration. Okay, once we get to trial, the first thing we have is trial brief. We talked about trial briefs last week. Trial brief has everything that is anticipated to come up at trial. So you have your complaint, your answer, all your pleadings, but then you have all of your arguments, all of your witnesses, all of your items that you would like to introduce into evidence. You are anticipating motions. So you want motions in limine. That means motions before the court outside of the presence of the jury, where you're just before the trial, where you're trying to say, hey, I want a motion to bar this evidence or to make sure that this evidence is introduced. So the trial brief is super, super important. Okay, then once that's all filed, you have jury selection, right? You have the voir dire, where you interview the jurors. You have certain, automatic ones that you can just say, I don't want you. You might have some that the judge excuses, some that both parties agree on excusing, until you get your jurors and your alternates. Okay, and then you have at your trial, each party has an opening statement. First, the plaintiff then brings their case. They present witnesses, they present evidence, and the witnesses are cross-examined by the defendant's attorney. Then the defendant brings their case. They can introduce evidence, they can bring their witnesses, and those witnesses can be cross-examined by the plaintiff. Then each party has an opportunity to address the jury or the fact finder with closing statements. Then the jury is instructed by the judge as to what they have to find, as to the legal standards that they need to uphold. Then the jury is dismissed for deliberation, and they make their decision. So in civil cases, I think it doesn't have to be unanimous. It just has to be a simple majority of the jury. And then the jury makes their findings, and then the judge enters a judgment based upon the jury's findings. Okay, so then if some party is not happy, they may appeal. So the first thing they do on appeal is they file a notice of appeal. They have to post a bond. You can't just file a notice of appeal. They have to put money down. Then that party who is appealing, the appellant or petitioner, whatever you want to call them, has to compile what's called the record. The record is every document related to the trial. So you have to order the complete trial transcript. You have to have all the evidence. You have to have motions, everything that happened at trial. Okay, then you file a trial brief, and then the appellee or respondent or the other party would file their responding brief, and then the appellant files a reply brief. There's a date for oral argument. There's an oral argument before the panel of judges, and after a certain period of time, the court makes a decision and writes an opinion. And in some instances, a party may appeal that decision, and then there's a second appeal, and we start all over again. Oh boy, that was a lot of work. So that's how you do it. Hopefully that's all stuff you learned in litigation, and it's a bit of a review, but it's always helpful to talk about it. Okay, so part of what we were talking about in this civil litigation story is motion practice, and that's part of what a lot of attorneys spend their time on, is motion practice. Okay, so what is a motion? It is a request made to a judge for some sort of order, and this is usually at the trial court. And they'll say, I want a motion. I'm moving this court for an order to dismiss this case. I'm moving this court for an order compelling discovery from the other party. So it's always in a pending case, and we make motions at all stages of the legal process once the case has actually been filed. So early on, you have, motion for change of venue. I think this is an inappropriate court for us to hear this matter, so I'm moving to change this, or I'm moving to dismiss this complaint for failure to state a claim, for some sort of defect in the pleadings. In the middle, you have motions for summary judgment, motions to compel discovery. In the pre-trial stage, you have evidentiary, these motions in limine. And perhaps during trial, you're going to have evidentiary ones or disputes as to the content of the jury instructions. So what do we do? The first thing you do, you have some sort of thing that you were going to want the court to do. So someone drafts a motion. Okay, you perform legal research to support your motion. You compile your supporting documents and affidavits as needed. And the opposing party has to be served. The motion will have to be filed or e-filed with the court. And then there's a court date to hear this motion. A lot of times at that court date, if it's something procedural, the court will make a ruling on that date. But if it's something more complex, the judge will say, well, let's set a briefing schedule on this. We're going to have everybody have an opportunity to do their legal research and present their best arguments. So then the responding party would file a response to this motion, and then the moving party will file a reply to the response. There is a date for some sort of kind of oral discussion or oral argument on the hearing date. And then the judge makes their decision. Sometimes they make that decision on the spot. Sometimes they take an opportunity to think about it. Sometimes the judge, especially in federal court, they don't even always hear oral argument. They just make a decision on the briefs. And then they'll issue an order, and then the order is their final ruling on the motion. So in civil, we have motions on the pleadings, has things that their motions to dismiss, have they correctly stated a cause of action? Maybe they're moving to amend their complaint, moving to overturn a default judgment. Maybe they're trying to bring in additional parties. All sorts of stuff regarding the pleadings. You may have motions regarding discovery. Maybe you think that you want a protective order. Maybe you don't want to turn over confidential commercial information to this opposing party, or to compel discovery. Those are things related to discovery. Summary judgment. So summary judgment is a special kind of motion where you were trying to basically get the judge to make a decision without a trial. And a summary judgment is allowed if basically all the parties, the facts aren't in dispute. So there's no genuine issue of material fact. And if the facts are not in dispute, a judge can make a decision only on the law, right? Because you don't need the fact-finding aspect. The judge is always the one who is the arbiter of the matters of law. So if there's no factual dispute, you can move for summary judgment. Now, and as a practical matter, it's really hard to get a motion for summary judgment. But it is helpful to often draft a motion for summary judgment so you can kind of figure out where your holes are in your story that you're going to be telling the jury, or maybe even as a way to get the judge to hear your side of the story before it goes to trial. Evidentiary motions. So you want to either make sure that a piece of evidence is included or a piece of evidence is not included. Think about, the Peterson case, right? Those were evidentiary motions. Okay. After the trial, after the judgment, after the trial, but before the jury gets the case, people make a motion for judgment as a matter of law. So they're saying that this one, if everybody just kind of files this as a matter of course after evidence is completed, to say that, well, you heard all the evidence. There's no dispute as to fact. My facts win. And they say that because the facts are established, you can make a decision as a matter of law. Again, you've gone through the whole trial here. The jury sat through it. They're going to give it to the jury 99.99% of the time. After a jury issues their ruling or their findings, if it's not in your favor, you may file what's called a motion for judgment NOV, notwithstanding the verdict, saying that the jury must have been on drugs. They made a really stupid decision. you should rule despite the jury decision, which again is very, very, very rarely granted, but it is always filed. Motion for new trial, if you're claiming, maybe there was juror misconduct or some sort of misconduct or big mistake or something prejudicial, you might say, we need a new trial. In criminal cases, changes of venue are more common. Motions to suppress evidence and motions to dismiss are more common. Where you're doing your research, first thing, you have to have a basis for your motion. So you look through, depending on if it's a civil or a criminal case, you look to either the rules of criminal procedure or the rules of civil procedure if it's a civil case. Make sure you have a basis in the rule for your motion. Okay, so you need a rule and then you need a legal basis as well. So is your legal basis, statutory, or is it a common law basis for the motion? Check your, if you're looking through statutes, check your annotations, or if you're looking for cases, check your digests to find cases both on the substantive and the procedural law. So here's, hopefully this link still works. Illinois Code of Civil Procedure, the code section that allows for motions with respect to the pleadings. There's actually, so here's your pleadings, and then here's your motions. Motions with respect to the pleadings, right? There's 2615 motions, there's 2619 motions. So this is, it's kind of a procedural. There's defects in the motion. In the pleading. So that's kind of what I mean by your legal basis with the rule, but then you also need substantive basis for it. So you're like, well, the pleadings are defective because they haven't established a negligence claim. So then you're like, okay, it's that rule that we're basing the motion on, but now we have to find our case law that says what are the elements of a valid negligence action in these particular factual circumstances. So it's kind of a two-part research process. Motions can be super short. If you have something like a motion to compel discovery, hey, I filed a motion, interrogatories on this date. They had 30 days to respond. They didn't respond. I wrote a letter. They still didn't respond. I made a phone call. They still didn't respond. I really want a response. And then you just file your own affidavit or maybe records of the letters that you sent or something in support of that. If it's a more complicated issue, you can file just a simple motion with your rules and your law, and then you file a memorandum in support of the motion to support your motion. So they would call that, in your Hamey's text, they call that a memorandum of points and authorities. The supporting documents that you would include in your motions are usually called exhibits. So you might have affidavits, declarations, you may have copies of letters, records, deposition, transcript, excerpts, anything that you are referring to in support of your motion. Make sure you do a good job to organize those supporting documents. I have a funny story. When I worked at the U.S. Attorney's Office as a college student, and I was told to photocopy a motion, and in the motion, these exhibits were deposition transcripts, and then I got all mixed up, and I organized the deposition transcripts by the page of the deposition rather than like the exhibit number. So I really screwed it up big time because I had no idea what I was doing. So hopefully you guys have a lot more idea of what you're doing than I did when I was, 18 years old and in college working at the U.S. Attorney's Office. So what happens after you file your motion? How are they disposed of? You can have a long oral argument or very short. Parties can agree on orders, or maybe they're disputed. Judges sometimes make their decision right away. Sometimes they may take it under advisement and write a written ruling later. Judges may say, there's no oral argument. I'm just going to look at all your briefs, and I'm going to make my decision based on those briefs. But the judges, when the judge makes her decision, it is final, and it is in the form of what we call an order. The order might just say, I move for, I grant the motion, or I deny the motion, or they may have reasoning, like almost like a little bit of a mini decision here. Depends. Federal judges usually will give you more reasoning than state court judges. But that it is just more of a matter of style of the judge. Along with your motion, you have to file what's called a notice of motion, and this is again where you look at your local court rules. It tells all the parties about the time, place, nature of the motion. This might be something that you will need to do, so make sure you familiarize yourself with the local rules in filing your notice of motion. All right, so now let's talk about appellate briefs. Okay, appellate briefs, they are filed during the appellate process. We talked a little bit about them last week. Don't confuse them with case briefs, right? An appellate brief is a big, long argument to an appellate court based upon a claim of legal error in the trial court. It is a persuasive type document, remember, characterized by advocacy. We're arguing for our client side over the other side. When in the civil or criminal litigation process, the trial court reaches a final decision, right? A final order is issued. You can only appeal a final order. And if one party is dissatisfied, they can file for leave to appeal. They have to believe that the trial court made a legal error, not a factual error, a legal error. They made an error interpreting the law. The party bringing the appeal is the petitioner or the appellant. The party opposed to the appeal is the appellee. And usually you get kind of one chance to appeal. The second level of appeal is discretionary by the court. They may or may not hear that appeal. So the grounds for your appeal, you have to have a basis in the record below. You have to have the party filing the appeal must have raised this issue at the trial court level. You have to give the trial judge an opportunity to make the right decision. So you have to make that motion. You have to object to that line of questioning in an examination, an examination. So that is why you see this on in these trial court movies, the courtroom dramas, that the attorney will object even if they know that the judge won't rule on their side, because they're preserving this issue for appeal. If you don't raise it at the trial court level, it is waived. You're out of luck. You can't raise this on appeal if it was not raised at the trial court. It can only be issues of law. It has to be what's called material error. So if you just make a decision that doesn't affect really the final outcome, the appellate court will say this was not maybe the trial court made an error, but it was not material. It did not affect the juror's decision, and they won't allow the appeal then, or they'll call that harmless error. So you have material error where it really made a difference and we need to correct any error. But if there was an error that didn't make a decision, they'll call it harmless error, and then the trial court decision will stand. And it has to be a final order. Okay, usually appeals are filed after the completion of, goes to jury and you have a final judgment. That's the traditional sense, but sometimes it is an appeal of a final order. Our own example of that we've seen where it hasn't been at the end of, after the jury's gotten all the information, was in Peterson. Remember, that was before this evidence was even presented to the jury at all, and it was paused because we were appealing a final order, but not before the completion of the trial, and we call that an interlocutory appeal. The record, right? That's everything that happened below: trial transcript, all written documents, all evidence admitted to the court. The record can be a huge, huge, huge document. Oh, see, these are things I talked about. The issue must have been raised. Material error, final order, interlocutory appeal. That was the Peterson example. If it's an interlocutory appeal, nothing happens in the trial until the appellate court makes their decision. The trial court is paused during the interlocutory appeal. Procedurally, you need to file a petition for leave to appeal. A bond needs to be posted, the record needs to be compiled, and if you are helping someone or working at a firm where they're doing an appeal, you have to look to the rules of appellate procedure and rules specific to this appellate court that make sure you're doing everything correctly with the way the documents should be looking, the timeline. You can't miss deadlines. You're totally out of luck if you miss deadlines on appeal. The content, and this is what you're going to be working on in your homework, is looking through what an appellate brief really looks like and comparing it to what our textbook says an appellate brief has to contain. But you need things like a table of contents and table of authorities. If you are making statements, factual statements, that needs to be referenced by the record. An appendix to an appellate brief may have these pieces of the record. They may have evidence. They may have texts of laws or portions of the record. And remember, the super important part of an appellate brief is they are advocacy documents. They are persuasive. They are not meant to just have a little conversation about the law. They are meant to persuade this panel of judges to rule in favor of your client. Okay, so these are some terms that we talked about. Remember, interlocutory appeal, material error versus harmless error, the record, waiving things on appeal. Okay, so don't forget about your homework and getting your quiz done, and don't forget to continue to work on your final project. And I will chat with you next week, unless for some reason you want to chat with me sooner. Have a great one.